Sorry, yes, you have it on the screen. Sources of criminal law, as I said, you also have the huge importance of procedure. So we're going back on what is criminal procedure in England and Wales. It's not Scotland and it's not on Northern Ireland, okay, because both of them can be quite different. So sources of criminal procedure. The first thing you have to remember is you don't have a definition of the offences according to their seriousness, but according to the procedure they're going through. So, and also the vocabulary, crimes in English doesn't mean les crimes, c'est les infractions. D'accord? So crimes are defined according to the procedural rules that are going to be applicable to them. So you have three. The reality is that they correspond, because of the sentencing that goes with the procedure, to the seriousness of the offense, but they are not in themselves defined by that seriousness, okay? It's a consequence. So summary offenses, summary only offenses go before the magistrate courts. Indictable only offenses go to the Crown Court, and they're more or less the two extreme. Triable either way, they can either be summary or indictable offenses. Okay, so it's theft, burglary, it's actually most of the offenses. Okay, indictable only are going to be murder, manslaughter, rape. Summary are going to be assault and a couple of others, but more or less the bulk of offenses are triable either way. Triable either way in French code, French criminal code, will probably be a mixture of contravention and délit. It depends. But some of the contravention can be quite high and it still be triable either way in English terms. So there is a reflection on seriousness, but the definition is first according to procedure. And it used to be defined by the seriousness, and it used the old distinction, which didn't match again its French equivalent. It was treason, felonies, and misdemeanors. Misdemeanors being officially the minor ones. The reality is there could be as much a contravention as a délit. Felonies were really the crimes, but theft was a felony, for example. So theft is a délit in French, but in English terms, it would be felony, and it would be what the term would correspond to un crime en France. So it's a distinction that used to exist. To be honest, it was also linked with the procedure, and it was actually abolished, but the terms of felonies and misdemeanors, you found that in the US. It's very much still there, so be aware of it. But really, you have no classification as in Article 111 du Code pénal, which means that you need to think about which court and which sentencing powers goes with the court. Magistrate court, their sentencing power is limited in any case. Whether they're competent on triable either way or they're competent for summary only, their sentencing power is always limited. So it used to be 6 months imprisonment for one offense, obviously, maximum 12 months if you had 2 or more offenses. It has at last been increased to 12 months to 15 months. It's the Criminal Justice Act of 2003, but it never came into force before 2014 because it needed the statutory instrument to be published. In 2012, they also increased the 5,000 fine, maximum 5,000 fine, to any amount, which means it's unlimited. Okay, so that is an increase, but it's very recent, 2014. And it reflects that magistrate courts can be for summary only as much as triable either way, okay? And triable either way can be theft, can be fraud, a lot of offenses where the fine should be at least more than £5,000. The outline of criminal procedure, I will show you a PDF then a scan so that you can see it better. Magistrate courts are composed of lay justices or one district judge on his own or two lay justices. For example, family courts in England, it's usually lay justices, so people like you and I. Some of them had absolutely no legal background. They are trained before they become magistrate justices to have a legal background, but they are not necessarily chosen for their legal expertise. It can be simply about giving time to the local community, you know, servicing the local community. So it's very much a different process from the professionalization of French judiciary. So magistrate courts, lay justices, and district judges. Usually for criminal law, it tends to be one district judge on his own or with two lay justices, rarely just lay justices, because it's too important and they want also to avoid mistakes. Jurisdiction. So jurisdiction, c'est la compétence, hein, c'est pas la notion de juridiction de cour. Jurisdiction, magistrate court can be for summary offences, triable either way, and indictable offences. But there can be a judge who decide whether the person is guilty or not. Triable either way also. But for indictable offences, they're just a filter to go to the next stage, which is the Crown Court. And a filter, they're not deciding whether the person is guilty or not. They're just saying, assessing the likelihood of the case and then giving bail, usually. It's linked with bail. Donc la détention provisoire. So summary offences, the magistrate court indeed decide whether the defendant is guilty or not and give the sentencing. Triable either way, it depends of what the defendant is doing. If the defendant pleads guilty, the sentencing will be given by the magistrate court, okay, unless it's above their sentencing power. So unless they can't give more than 12 months or 15 months imprisonment, and they want, for example, 10 years, then the sentencing will not be by the magistrate court, but by the Crown Court. Okay. Defendant does not plead guilty. In that case, it's just, the magistrate court does not decide on the conviction, so whether the person is guilty or not guilty. It's just an allocation hearing, so it's going to choose which court it's going to go to, okay? And usually it goes to Crown Court. Indictable only, then the magistrate court only look at legal aid, the bail, so la détention provisoire or remand. Crown Court. So Crown Court is not necessarily the upper echelon, it's not necessarily above the magistrate court, it's more at the same level. They're composed of judges, you have a jury. In London, the famous one is Old Bailey, that's its old name, okay? It's because it's where it is. And Old Bailey is where you have all the Inns of Courts, which are not called anymore Inns of Courts, they're the College of Law, where you have all the chambers with the barristers, and not that far away from actually Parliament. If you take a map of London, you can see the centrality of power, because more or less Parliament has the Prime Minister, and next to Parliament you've got the courts. Crown Courts, jurisdiction, so what are they competent for? First instance, so they decide whether or not the person is going to be guilty. So when the defendant refused to plead guilty, when they refuse the summary trial, so before the magistrate court or for sentencing, and they can be the appellate court. Okay, so then in that case they will be above the magistrate court if it's not a point of law and not an acquittal. Okay, so you need several conditions. You can't have them being an appeal court as such. So I think it will be easier if I get out of this and show you the, that's it. Mind you, I don't know what you can see from there, from where you are. So if we take the distinction that we've seen, summary, triable either way, indictable, you start here. Okay. Summary only will be dealt by magistrate court, and usually the sentencing reflects it, so there's no way that it goes to the Crown Court. Either way, we have a plea of guilty, magistrate court alone, unless it's above the sentencing power. Not guilty, then allocation, so you have bail, and then it goes to, if I move the document, it goes to either the Crown Court, or if they accept summary trial, it's tried at magistrate court, so without a jury. That's what it means. Now, indictable only, it starts in magistrate court for funding, so legal aid, bail, and remand, but then it is sent to the Crown Court. Okay, so it's quite a complex system. It's not at all the way it works in France. I should have, that is, this time you reverse, you start at the bottom to go up. So Crown Court hearing indictment, so indictment only, or when the person refused to plead guilty, hears appeals against conviction and sentences. If you have this, then it will go here. If you have that, it will go to the Court of Appeal. So trials on indictment, then it could be Court of Appeal. And it's only by the defendant, so the prosecution cannot go to the Court of Appeal. And it has to be obviously open conviction or on the sentencing. And to be honest, on the sentencing, it's very frequent to have the Court of Appeal. It's far less frequent to have it on the conviction. Okay. And you can see here magistrate court, all criminal cases except if it is before the Crown Court. And then at the very top, you've got the Supreme Court. Okay. But the Supreme Court, to be honest, the Supreme Court has about 100 cases a year, so the likelihood it ever goes to the Supreme Court is very remote. I think that was it after, yeah, this is something else. So, what is the proportion going to Crown Court and with the jury? So the Crown Court, the feature is the jury. It's like in France, 1% of criminal trials, which is about the case for la cour d'assises. La cour d'assises, on oublie, mais il y a très peu d'affaires qui vont en cour d'assises. 98 to 99% of the cases are dealt by the magistrate court. MC is the magistrate court. Okay? When they have the choice, and you remember in France the defendants don't have the choice. In England they have the choice. They can go to the Crown Court with a jury, or they can just go to the magistrate court. Only 1 out of 20 defendants chooses the Crown Court with the jury. So it's very, the chances it goes to a Crown Court with a jury is very remote. Jury decides on facts. It has to be a unanimous verdict. So it is 12 out of 12 people. There is no professional judge deciding the verdict with the jury. That's completely different from the cour d'assises. La cour d'assises, c'est non seulement le jury, mais c'est le président. D'accord? Donc c'est complètement différent. And it's shocking for an English mind that the professional judge can be with the jury. They decide on fact only, so not on the interpretation of the law. They don't have to give motivation. So they don't have to explain why they reached that decision. And you can have non-unanimous verdicts, so what they call a majority at 10-2 or 11-1 after 2 hours of discussion, okay, and if the verdict is reached. The judge will decide on points of law and will give direction to the jury about the law. So in order to decide the facts and understand the consequences, the judge will explain the law to the jury. And a lot of appeals in English criminal law will be about the directions given by the judge to the jury. So it's, properly speaking, it's not an appeal on the decision and the reasoning for the decision. It's an appeal on what took place prior to the decision, okay, and prior to the reasons given, or not given actually, right? So it's very, very different. It's like if, pour la Cour d'assises, it's like if the Président de la Cour de cassation were explaining, or la Président de la Cour d'assises were explaining the law, so the definition, say, of murder, and the appeal will be on that explanation, not on how the jury reached the decision. Okay, so very, very different. Appeals are also very rare, to be very honest. The Crown Court, it can only be the defendant, can't be the prosecution. It can be on conviction, so on the decision that led to the conviction. It can be on the sentencing, or on both. It's not frequent, but if you have an appeal, it might go to the High Court. The High Court may be only on the point of law, not on the facts. So again, it's not the same as France, where the Court of Appeals, donc les cours d'appel, peuvent avoir le fait autant que le droit, alors que là, la High Court peut avoir que le droit. D'accord. If it goes to the High Court, it can go to the Supreme Court, and if it goes to the Court of Appeal, well, the Court of Appeal has been created for criminal cases, not for civil law cases. For criminal cases, it only dates from 1907. Okay, so it's very recent, and it's a bit the equivalent, if you like, of les cours d'assises d'appel. Okay? Except that the Court of Appeal does not have a jury. Okay, and the only thing that it does is that it looks at the decision. And if it finds that the reasons for the decision that led to the convictions are unsound, it sends it back to a Crown Court. So it sends it back to the jury again. Okay, but it doesn't decide on the outcome, it just looks at the law. So it's quite narrow. It's not impossible to reach the Court of Appeal. I don't have the statistics here, but it's very rare. I think it's less than 10% of cases. So it's not at all like in France where you go en cour d'appel and it's quite frequent, and then you go to the Supreme Court, la Cour de cassation. Not at all. More or less what has been decided at Crown Court level or at Magistrate Court level is very likely at 90% to stay there. Okay, and not to have any appeal, whichever form it takes. Now, other courts, as I said, you have the Privy Council, so for non-English cases, so Caribbeans and the rest of the Commonwealth. At one point, you even had New Zealand until it has its own Supreme Court. You also had Australia not that long ago. Now, once the decisions has been stated and has been accepted and confirmed and as binding authority, you can't have appeal and so on. It can go to the Criminal Cases Review Commission if there is what we call a miscarriage of justice. Donc l'erreur judiciaire, c'est miscarriage of justice. It's here. It's also a very recent body, 1995. There are a lot of issues today with England because there is nearly no legal aid anymore. There's no legal aid in civil law. Okay, it's finished. L'aide juridique en Angleterre, c'est fini. Pas en Écosse, mais en Angleterre. Pour le civil, les affaires civiles, il n'y a plus d'aide juridique, c'est terminé. Il n'y a pas un sou qui vient de l'État. Pour le droit pénal, c'est en train d'être réduit au point que ça pose problème parce qu'en fait, on sait très bien qu'il va y avoir des erreurs judiciaires. Mais il n'y a pas d'aide juridique c'est en train d'être diminué au point que ça devient une farce presque. Donc, Criminal Cases Review Commission was implemented because of scandals about essentially the problem of the police. Police investigations that were biased, sometimes corrupted, completely contrary to legal rules in terms of evidence, how you gather evidence. And it's a lot of scandals, but it took ages to get those people through the system. It took, I think, for the Guildford Ford, I think it took nearly 20 years, and of the 4, I think only one has survived and is more or less mentally ill on depression. So very harsh, and to be honest, with the lack of legal aid, I have that feeling that English law is not getting better. I'm certainly very much against the current trends. So we have finished with this introduction to the sources of criminal law and how common law statute and criminal procedure shape criminal law. And now we're going to enter into the that's it. So the different elements and the conditions for criminal liability. So we're not going to review everything, but it's just trying to give you the main features. And to be real honest, I think when you review, try to take your Code Pénal and go to the library and look at it, or go to Légifrance and have a look of it, because I think it shows the differences quite well, and you can see that better, I think, the differences. So remember, there's no code, so there is no definition about intention, like in 121.3. There is no definition of the conduct. There is no definition in the statute form in most of the defenses. So condition for criminal liability, you need a person, you need an offense, and you need what we call in English no actionable defense. Just wanted to, that's it. So very strong similarities. You seem to have the same elements. The reality is that you have huge differences. So the first thing we're going to look at is the offense and the two elements. Again, apparently very strong similarities. You've got l'élément matériel et l'élément moral. So actus reus, a conduct and the consequences, and the mens rea, the mental state of the defendant. Okay, it can be intention, non-intention, and so on. So apparently you've got very strong similarities. It's true that the definition of actus reus and mens rea, so actus reus is Latin for the act in relation to the object, and mens rea is the mental state, mens being the brain. So it comes from Latin. It has no statute basis. It's from Cook. Okay, we pronounce it Cook, not Coke. It's one of the institutes of Cook, which was in Latin, and they kept the wording. They tried to explain it and change the wording. Okay. So I just wanted, that's it. And so, my lords, it would, I think, be conducive to clarity of analysis of the ingredients of a crime that is created by statutes. If we were to avoid bad Latin and instead to think and speak, as Stefan, that we already cited, about the conduct of the accused and his state of mind at the time of that conduct, instead of speaking of actus reus and mens rea. The wish of Lord Diplock has completely been not granted at all, and we still are left with actus reus and mens rea. Law Commission used external elements for actus reus, which I personally find it really confusing, and fault element, which also it can be confusing because the notion of fault usually implies intention and not non-intention involuntary actions. So mental element is the wording used for mens rea in Joggi and Radok 2016. So l'élément moral, l'élément matériel. Now, actus reus itself, standard elements, again, you don't see at first sight the difference. The standard is to have a conduct and a result. The minimum that ones need in an offense, especially if it's statute-based, it's a conduct. Okay? A result that is incorporated into the offense definition but is not realized, so it doesn't happen, then will lead to an attempt, donc c'est la tentative, hein, ça c'est pas compliqué. But the English use a special word, they call it inchoate offense. Okay, it's not necessarily attempt. The first word used, it's inchoate, which means undeveloped. Okay, so more or less it means the offense that hasn't reached the result. An attempt is not possible for summary-only offenses. Okay, so you don't have les tentatives de contravention comme en France, c'est pareil. No attempt to conspire, so no conspiracy, and no attempt to commit an offense as an accessory, so no attempt to try to be an accomplice. Now, you have a specific vocabulary, but because criminal has not been hugely influenced by scholarship, donc par la doctrine, and has been mainly case law based, you have a couple of distinctions that you have in French law will not be in English law. So the first thing is that the offenses that do not have a result in their definition are called the conduct crimes. Okay. But there is no difference between les infractions obstacles et les infractions matérielles. L'infraction obstacle, je ne sais pas si vous vous souvenez vaguement, c'est le port d'armes. D'accord ? C'est simplement le fait d'avoir une arme, généralement sans autorisation. L'infraction matérielle, c'est simplement généralement l'infraction où il suffit d'avoir la conduite sans avoir l'intention, par exemple, du résultat. Donc, par exemple, la négligence. Most conduct crimes in English law do not require mens rea. There is no intention, no recklessness, and no negligence. Okay? You just have to do the conduct. So usually what it is, it's linked with statutes, and the typical example is health and safety. A person has not complied with health and safety measures, so for example, has not secured a ladder when using it, or has not worn a helmet. The simple fact of not having done that leads to the liability. Okay? There's no inquiry about whether the person was negligent in doing so, whether the person was reckless, so mise en danger délibérée, or whether it was intentional. It's just a simple fact of not complying. They are referred as offenses of strict liability. It's very much criticized, to be honest, those type of offenses. Usually they are associated with light sentences, so no imprisonment, usually a fine, but no imprisonment. The reality is that there is an increase of criminalization, especially in public health and safety, where strict liability offenses are associated with 4 or 5 years of imprisonment, a couple of £1 million of fines, and there is a whole academic movement criticizing this. But it is a trend that is really there. And even in traditional offenses like fraud, so big offenses like fraud have been redefined to avoid having a result. So l'escroquerie, la fraude c'est l'escroquerie. Ça peut être aussi l'abus de confiance d'ailleurs, parce qu'il y a 3 manières de commettre la notion de fraude, et une de ces manières, c'est l'abus de confiance, misuse of trust. Okay? But fraud as escroquerie, so the fact of lying and then getting the person to act in a certain way to get property, it has been defined in such a way in 2006 that you just need to literally lie. And it doesn't matter what the result is. So it doesn't matter if the person actually does not give the money. As long as the person has misrepresented the reality. So claim to be somebody else, claim to have certain things, and so on. So it's a offense that has completely changed, because before that, before 2006, you needed to deceive the person. So it's not simply to lie to the person, but to make sure that the person will give the property that you wanted to obtain. This is not anymore a problem. It's simple. It's simply to misrepresent reality. It's also a trend with the Computer Misuse Act and new technologies, where often the sentencing is raised. Now, there is a reason why they want to raise sentencing, and sometimes it's simply linked with extradition. Because if you use the European arrest warrant or the extradition procedures, if you have a minimum of sentencing, which is usually of 1 year, then it makes life easier to extradite people. So, conduct, the question is, well, normally the expectation is to have a commission, so positive action. The question is, do we have omission in English law? Now, I always found it quite strange, because the English law will always say that it does not recognize a general obligation on citizens to act in a particular way. So to act to save another or to prevent physical harm to others. Okay? And usually at that stage, they quote French law and say English law does not have l'omission de porter secours. Okay? L'infraction d'omission de porter secours. 2236. That is correct in the sense that there is no offense in English law equivalent to l'omission de porter secours. But that is completely incorrect about the possibility to be liable for omissions. English law recognizes a number of situations and actually recognizes 5 scenarios where you can have liability for omissions. One scenario is to have a statute, and it's usually linked with public health and safety. But another one, for example, is dangerous situation. If you create a dangerous situation yourself, then you have a duty to act. And then if you do not act, so you have a breach of the duty to act, then you are liable for negligence. Okay? So it's officially it is true. There is no duty offense like in French law. The reality is that the diversity of circumstances that gave rise to liability is far broader than French law. So it's a paradox, because English law will always say, oh, we're not like French law, we don't have l'omission de porter secours. And the reality is that you can have a duty of care, so a duty to act, and if you breach it, it's criminal negligence. For example, within a family relationship or even outside a family relationship. So the person has been found liable for manslaughter, so l'homicide involontaire, d'accord? It was a drug dealer. He gave the drug user collapsed in his house. He didn't call the police, you can imagine why. Okay? He was found liable for manslaughter. Okay, pour homicide involontaire. Why? Because he created this dangerous situation. He act open that dangerous situation, and he should have called the police and the ambulance at least to save the person. Okay, it was calling the ambulance and not simply the police. So it's actually very broad, and contrary to what English law says, it's, I think, in certain cases broader than what French law would allow, even under l'homicide involontaire. And it's certainly the conclusion that gives Eliot, and the book has not been updated, so if you have it in the library, it's still perfectly valid. That English law is actually broader than French law in relation to les conduites d'omission, les actes d'omission. So the other aspect of the conduct in English law, so you have commission, omission, it's whether the conduct must be voluntary or not. And it's not a concept. Le concept de la volonté, en droit en français, c'est dans la notion d'élément moral. C'est pas dans la notion d'actus d'élément matériel. But in English law, the conduct has to be voluntary. Okay? It's that notion that the conduct expresses a willingness to act in a certain way. Okay? Not necessarily intention, but willingness. And it gets against the defense of automatism, which we'll find next on Wednesday. French law, voluntariness is not part of l'actus reus, it's part of the mens rea avec la faute contraventionnelle. You need causation, typical, le lien de causalité, ou bien qu'il y en ait un, between conduct and result. And you have two tests in English law, and you need the two together. The first one that we have to start with, it's called factual causation. It's the but-for test. More or less, it's about proving, if you have a chain of events, that each event contributed to the result. It's not about proving the liability as such of everybody. It's just saying, well, those events happened. We know that for sure they happened, and they all contributed to the result. Now, to look at the legal consequences of that, it's called the legal causation. And liability only exists if the conduct is the operating and substantial cause to the result. Okay? And it's really important, is that notion that, and you have several wording on it, so salience, significance, proximate cause, and so on. It's that notion of chain of events when you have different defendants. And a typical scenario will be given of the defendant had a gun, shot somebody but aim only at the arm, so intention was more for grievous bodily harm and not for murder or manslaughter. The person goes to the hospital is negligent. Is the negligence of the hospital breaking the chain of causation? The answer is no, usually, because the person, if the person had not shot the victim, the problem would not have existed, and it is the operating, the substantial cause that lead to the result. So, factual causation and legal causation. And in terms of theory, that's about it for English criminal law. So all those theories about l'infraction complexe with different elements. L'infraction d'habitude, you know, the ones that repeat, you need two conducts repeated to have the offense. The typical ones, c'est le harcèlement. You need the repetition. You don't have that notion yet. You have for harassment, you do have the need to repeat, but you don't have a theory on it. Donc, pas d'infraction d'habitude, pas d'infraction instantanée, et pas d'infraction continue, ça n'existe pas. Okay? So all the theories that you find in French criminal law and you open the book, all these are completely unknown. To be honest, they're quite practical when you do study, and I would like to be able, because it's very difficult to actually translate some of this, be able to use it in English criminal law, but that's life, you don't have it. It's 10:02, so I think it's time I'll finish. We'll continue with mens rea Wednesday. Okay, and by Wednesday you should have that on c'est la FDV, non? Vous appelez ça, non? Hein, voilà. Donc, vous devriez la voir avec les documents que je vous ai montrés et puis l'arrêt de Joggi. Hein, voilà. D'accord? À mercredi et merci.